first to thank colleagues who have expressed some of the feelings I had. One as a court user for over 20 years now. Let me commend the judiciary, first of all, for the decentralization of services. That you now have high court circuits across the country, and that Ugandans do not have to travel very long distances to access justice at a higher level in the event that they are not satisfied with justice at the lower level. But the first question relates to the quality of justice and personnel. You go to one judge, get this judgment, the following day you get another one, the precedent is different, in some cases even when the law is very clear. Personnel. One day I met the principal judge, back then, I will not mention which principal judge, and I said, oh, where did you deploy so-and-so? I said, he's there, that one. Oh. But you know you don't allow me to fire, so I can't fire him. And I said, yeah, but you could deploy such people in places like judicial training. He said, oh, he goes and trains them how to do that. You know, then you get some of the best. You move them from the stations where we need them. Need them meaning they are the engines of that particular court or station. And he says, so and so is taken to Judicial Training Institute, is taken to inspection, and so on and so forth. Administration, basically. Most competent, most senior, diligent at work. How you deploy, and now this is about deployment. You get very senior judges. You deploy them to places that have literally no work. This explains part of the backlog. Again, part of the backlog, I think Honorable Dula and Honorable Katuntu mentioned something. At some point, Chief Justice Benjamin Odoki asked a question. You adjourn a bail application. What is so novel in a bail ruling? More so sometimes in a magistrate's court. Someone tells you, I'm going to hear your case, but I'll hear your bail application 2 weeks, 3 weeks away from today. You are defeating the Constitution. Because in the Constitution, everybody is entitled to be free, except where the accuser places on your table justification for restriction. Isn't that the position of the law? Every innocent person is entitled to freedom. Now, you're aiding the state to incarcerate somebody who is innocent until 2 weeks when that person will come to justify his freedom. I think it's unfair. So apart from the Constitution, you're also encroaching on the budget, because prison has a budget. And that's why they keep coming here to ask for supplementary. We budgeted for 70,000 remand prisoners. We've got 180. Honorable Du talked about it a bit, especially these political prisoners. You get somebody who is battered, who is bleeding, and you remand that person. You do not even instruct prisons, go and keep this person from hospital. Instead of, you say, I'm remanding somebody to Luzira. You know, just next door in Kenya, Kenyans went and burnt their parliament. We do not want to see Ugandans burning our courts. Why? Because once the dignity of the court is questioned and shaken, we are in trouble. Because somebody would have taken me to court will use a panga, will resort to mob justice. Why I'm very passionate about bail is I have enjoyed bail for the last 16 years. Me, I'm on bail for 16 years. My daughter, who was not born, is 16 years. And when I go back to that court, they tell me, we cannot find the file. So I'm not discharged. I'm on bail, which is not extended. I'm waiting for an opportunity for court to cancel my bail and call me, or probably order for my arrest. I go and say, okay, finally my file is here. So we refer to you sometimes as colleagues. Honorable Katuntu said you are our lords. Our lords. Be lords. Be worships in all respects. The question of bail refund, why should it be so complicated? I remember somebody in my village said, you can try to pursue this bail refund for me. First, it was little money. It was a lot of money to that old person, and I could not defy. This is somebody who saw me grow. When I pursued and I decided to give up and get the money and give it to him. Bail refund is a problem. Why don't you streamline bail monies? Why do you charge a lot of money? Somebody has been arrested. Actually, somebody is a victim. The police arrest people, beat them up. We witnessed it in Kawempe recently. Someone has been boxed by the DPC. He comes to you with a swollen face. You remand him. Then when you choose to hear, you ask a lot of money, for a lot of money. These ordinary people, they pick on the streets trying to survive. Why do you make bail so prohibitive? We have guidelines on bail, by the way. I'm happy. Are they followed? Do you have a system that periodically reviews the decisions of these judicial officers? I would want to be one of them. I would want to aspire. And you know, for me, I'm talking about the judiciary carefully, consciously and cautiously, because it is my food basket. Okay? But I'm not suffering myself. If I'm suffering, would you want?
We should start thinking about going away from the guidelines and make a substantive legislation which sort of ties your hands. It's very unfortunate because we want a judicial officer to have the discretion to exercise it judiciously. But if like is faced with a fait accompli purely by the law, then so don't make the legislature go to that level, because somehow you are not exercising that discretion properly.
Unfortunately, if you did that, I'll take you to court, and they will rule that it is unconstitutional because you have tampered with their discretion. You can now see. Somebody said, I will help you cross the river. You said, but there's no river. Said, I will bring one. Now, and we are speaking this because we want our systems to improve. So the quality of personnel. At some point, I had a matter where I raised an objection. And the judicial officer said, okay, ruling on notice. It took him 4 years to give me a ruling. 4 years on a preliminary objection, which I raised orally in 30 minutes. And when he gave me the ruling, guess what? It was 4 pages. So a colleague of mine cracked a joke and said, so he would write 1 page per year.
Yes.
I agree. We want to protect your discretion. We need it. And we do not want to do anything that destroys a small portion of the judiciary, because we run to you. when we are in trouble, when we have put ourselves on fire. But we do not want to get to that level. Finally, somebody talked about promotions. We see very many senior judges and their staff. Are you saying they are not competent? If they are not competent, is there a mechanism that determines the competence or otherwise, so that you fire them? If they are not competent to be promoted to the next level, and you bring junior people to go up there and review their judgments, then fire them. It means they're eating our money for free. But you must have a mechanism that assesses. A lawyer is told you file a defense within 15 days. The judicial officer will tell you, file your submissions by this date, and I will do that. And there is a sanction if I don't. Where is the sanction to the judicial officer who fails, who does not honor on delivering judgment on time or in time? So, with that, Mr. Chairman, I rest my case.
Thank you. I think this is a budget process. Let me start from there. I have sort of flipped through your figures. I have serious reservations on many of the figures you are presenting to us. Very serious reservations. And I would like to caution that in this budget process, we always have a limited resource envelope. The mistake many of us make as Ugandans, we look at the expenditure side and we don't look at the income side, because the budget is about what you have and how you spend it. So we emphasize more on how we are going to spend it, but we don't emphasize where we are going to get that money from. Now, having that in mind, tell us which are these critical expenditure lines, if not funded, the judiciary would be impaired. Meaning, we need priorities of priorities, which you must reduce in writing. Because if I go there and I'm looking at food, something like that, entertainment, and there's this big figure, I don't know how you expect us who sit again in the budget committee to be really arguing out this particular item to that level. So, Secretary, I want you to do one thing. Go back and look at your figures and say, without this, the judicial will be in trouble. Because when we are now going to be doing the negotiation, you won't be there within the budget committee to be the chairperson. Depending, forget about the report we will give, because eventually we will sit again in the budget committee to see how we can harmonize. What are your priorities? That's number one. Number two, I don't know whether you are very comfortable as a judiciary with the quality of justice you are dispensing. I have been addressing myself to, I think, Article 126 of the Constitution. You as the judiciary, are you comfortable with the quality of justice you are dispensing? Do you think the people of Uganda are happy with the way you are dispensing justice? Really? You may, I don't want you to look at me as this member of parliament, but anybody coming to you to seek justice in the courts of law, is he happy? And I'll give you an example. If you look at the figures of people on remand, it is inexcusable for a person who is seeking justice, and who is seeking justice, the complainer. He was the victim of crime. And 15 years, 20 years, that case that culprit has not been disposed of, a victim of crime. And the advantage I have is my first job was actually a prosecutor in the DPP's office. That was my first job. That you were a state attorney, you get a file, and you start looking for witnesses who witnessed a crime 15 years ago. I mean, you people, you just don't know the injustice you do to people. Because 15 years ago, somebody has grown, his beard is now older, and then he said, do you know the accused? The witness says, no. Have you ever seen? Said, no. Because 15 years is a long time. And you know, you see when an offense is committed, the witness doesn't have to have observed that incident for maybe hours. It could have been for only minutes. Seeing an accused for only minutes, and now you present this particular accused 15 years later, and you expect a prosecutor to have a successful prosecution. What a job. So, I want you to realize, as the judiciary, that there is a problem, and we must handle it. Some of us who have been your allies, I have been here for a short time, only 24 years. Yes, only 24 years in this house. I want to be a little bit longer. So, we now lose morale. You are saying you were demoralized, you are not being paid well. There is nothing humanly possible we need to do for you to be paid well. We did. And you must be happy as a judicial officer. You cannot complain. I'm sure you know that when the Judicial Service Commission is now advertising, people are even coming from Kenya, they want Ugandan judicial service jobs. It's a true story. Even, yeah, that sort of thing. You get it? So, as far as morale, you have no excuse at all about emolument. We have done what it takes to make you people comfortable as far as emolument is concerned. 2, numbers. Every other time we're increasing numbers. Even now we've just given them, we gave them the other day, so many judges. Even at the lower level we are doing the same. But what is the problem? Backlog, what is the problem? The average time to conclude a case is certainly way above a reasonable time. And the country cannot continue like this. Please. You need to come, go back to your chambers and say the people of Uganda are not happy. There are very few people who are happy with the way you people are dispensing justice. And I think it is so good. For those who have appeared in this committee, you know, this is the first time I speak like this. Because it's not excusable. For example, Mr. Jeremiah, do you know, there is this simplest thing called bail. Bail. And somebody adjourns the case for 2 weeks to grant bail. This is madness. This is purely madness. It is not professional. It's not legal. It's not common sense. It's not. Take a decision whether you grant or not. Simple. The only thing you can do is, okay, let's look at it the following day. But you had done for 2 weeks to consider bail, or even more. What are we doing, gentlemen? And some of you, we call you lordships, we call you worships. Actually, there's some we have baptized them and names they are going to be buried with. We call it justice. Why are you justice when you cannot dispense justice? I think this message should be clear that this is how the people of Uganda are feeling. Don't be lied to yourselves. Judgment or notice. I think we now need to ban this by law. Take this message, we want to ban this by law. Litigants have got a right to know when you are going to deliver their judgment. You can't say, judgment on a notice. You know what judgment on notice means? Or when I feel like, when I wish. A judge should be able to adjourn a case to a particular day for judgment. It creates certainty for the litigants. It creates certainty for the advocates, knowing very well their judgment will be on a particular day. If that day the judgment is not ready, they come and you explain. Say, look here, I'm sorry, the judgment can't be ready. You come back on this particular day. But you cannot just say judgment on notice, and you sit for 6 months, 1 year without a judgment. And you say, I'm justice. I'm justice cartoon. You've taken a whole year to deliver judgment. Just imagine the uncertainty you are posing to the litigants. Because what the litigants do, they eventually go to the lawyers. Then the lawyers, with all these unesco things, maybe the judge wants this, maybe the clerk wants this. Now they start troubling clerks. Can you people there? You know, what is happening? You know, because of that, there are so many unesco things that come on. Because there is that uncertainty. Why is the judge not delivering it, or a magistrate not delivering a judgment? Nobody knows. And lawyers are very uncomfortable to write, because you may take it up to them to write and inquire when you are delivering a judgment. The judge will say, well, if you want, I give it to you. And you know what you can do with that. So I think, Mr. Vigirimana, this message and the acting chief registrar should go clear that the public is not happy with your judgment on notice, and this is part of the backlog. Lastly, I could have spoken more and more, because there are few, I have been in that place for quite a number of years, longer than I've been here. Bar-bench relationship. I don't think the lawyers are happy with this relationship, the way it is going. The ordinary lawyers. At some senior level, especially you people holding these two positions, secretary and then the chief registrar, you need to have a way of sorting out this. It doesn't look good in the eyes of the public. Let's diagnose the problem. Where is it? What has caused this relation to deteriorate to this level, such that we seem like there is a war between the bar and the judiciary? What is it? Can't the leadership of the judiciary, because the leadership of the judiciary has an advantage, their leadership is a little bit permanent. The leadership of the bar has its own problems, because it is in and out, in and out. So you must, maybe if you are having a problem with the leadership of the bar, you must find a way of resolving it through either leadership of the profession to engage the leadership of the bar, and then the leadership of the bench to resolve this. Because it's not good. Obviously, sometimes the language itself is not like, when I was in the law school, I was never trained to use that sort of language. But these days, those who are born later than us, maybe it is all those who went to law school later. So, I think you two officers, you need to find a way of trying to sort out this. Because it's not good for our profession, it's not good for the sector. You must find a way of resolving it. It means, by the way, I don't have any solution. I don't know how you're going to do it, but you have to. How you are going to do it, that is your business, but you have to, because you have that responsibility. Is it going to be very easy? No. That I also know. It's not going to be very easy at all. But you must work on it and resolve that relationship challenge, resolve the impasse, engaging whoever you should engage, and we move forward as a sector. Mr. Chairman, I thank you. Sorry, I could have been a little bit longer, but I thought it was necessary. Thank you.
I'll have Honorable Seth next. Are you ready? But before you come in, colleagues, ladies and
mine are few chair, but in Uganda there is a problem. Just hear something like it's an allegation, and tomorrow we find it's like a law. Now there is something which is like acting capacity in the judiciary. So just want me to be guided or to be clarified on that. How is it applied and how can someone execute his role in that capacity as regards to judicial work? Because your side, Mr. Pierce, previously there are some judicial officers we've been having on functions. They introduce him and say, we are so happy to have just so and so at this function. People will start saying, oh, that one is known for just giving either reckless judgments or something. So I think that should be also be watched and get a clear guidance on that. Then chair still, on backlog, we need also to come at this site with a strategy, because we come here to plan for taxpayers' money. We credit Judiciary for nice buildings and what, but inside you are not getting what is. When you see the appearance of the building, it's so class, but services inside, they are not tally. So we need also to apportion somebody that as we are here giving money for same service for 20 years. Those were in Parliament previously. Honorable Fox's committee came up with a report, human rights, that there are people in the jail for 29 years, even in that. But that same person is paid for that, to hear that matter from day one up to 29 years. Someone should be either responsible to either pay for that service we've been paying for, so that someone will run the case as much as speed as possible to get at least something. When you go to lower courts chair, where we come from, now we have lower courts, sub-counties and town councils. You find what is there. The situation is around. People even learn because case land matters. They take long. They say, Mulamuzi, please help me, because when you take me far, I'll not get justice. Someone even without considering jurisdiction will just say that, Mulamuzi, please help, because when I go far there, I'll not get the best. 20 years even I'll be dead. See how to summarize it and I go. That's why even we have letters of administration which are not proper. So all those are issues basing on your mode of operation and the principle. The last one, Chair. And technology vis-a-vis the service delivery of justice. They hide in that we shall go on Zoom. You wait. Then they start either jamming the system or intending to frustrate or what. That one also we need. If we cannot properly address the issue of justice via this, let's put it aside instead of torturing Ugandans using that avenue. I thank you.
Thank you, Mr.